Members, good morning. It's the appointed time. We have a quorum. I call to order the meeting of the panel on manpower. Agenda item number 1, information papers issued since last meeting. The Secretariat has issued 5 information papers. They've been sent to members. Mr. LUK Chung-hung sent a letter on improving maternity protection for females, and Mr. KWOK Wai-keung, Mr. LUK Chung-hung, and Mr. Kingsley WONG wanted to talk about the policy on encouraging civil wage employment. Please note these papers. Agenda item number 2, items for discussion at the next meeting, the list of outstanding items for discussion and the list of follow-up actions. Deputy Chair Dr. Frankie Yan and I had a meeting with the Secretary for Labor and Welfare on the 21st of February 2025. We have related members' views proposed at the last meeting to the Secretary. Please take note. Some issues are in relation to manpower training. And these matters will be discussed at a subcommittee chaired by Dr. Frankie Yan. For some items, they will be discussed under another panel meeting. On retirement issues, they will be discussed under the panel on financial affairs. And regarding the qualification framework, it will be discussed under another panel. If members have no objection, we'll stick to the arrangements. And the next meeting will be held at 10:45 a.m. on the 24th of March 2025. The administration proposed to discuss 2 items. 1, the retention of one-time limited supernumerary post of Chief Labor Officer in the Labor Department, and 2, protection for digital platform workers. If members do not object, at the next meeting we will discuss these 2 items. All right, let's get down to business. Agenda item number 3, protection of employment rights of imported workers. Let's invite the administration to join us. We have with us Mr. Ho Kai-ming, Undersecretary for Labor and Welfare, Mr. Raymond Ho, Deputy Commissioner for Labor, Mrs. Suen Wong, Principal Assistant Secretary for Development, Mr. Simon Lee, Assistant Commissioner for Labor, and Ms. Catherine Law, Assistant Commissioner for Labor. Welcome. Members, if you'd like to speak, please press the button to request to speak. I now give the floor to Mr. Ho, Undersecretary for Labor and Welfare, to walk us through the papers. Thank you, Mr. Ho. Chairman, members, good morning. To cope with the challenges brought by manpower shortage and on the premise of ensuring employment priority for local workers, the government launched sector-specific labor importation schemes for residential care homes for the elderly and persons with disabilities, construction industry, and transport industry in 2023. We have also launched the Enhanced Supplementary Labor Scheme to enhance the coverage and operation of the previous Supplementary Labor Scheme for 2 years. The government attaches great importance to protecting the employment rights of imported workers. They are entitled to the same protection as local workers under the labor laws of Hong Kong. We formulate the standard employment contract, inspection, enforcement, and administrative sanction, as well as education and promotion. For imported workers imported under the said schemes, we have regulations on management of foreign labor service cooperation of the mainland labor service enterprises. Last year, for imported workers under the sector-specific labor importation schemes, the government is highly concerned about some cases in this industry. We have already set up an interdepartmental task force to follow up on these items. In September and December 2024, 2 persons have been prosecuted. Other involved persons are on the wanted person list. The government has adopted different measures to protect imported workers imported under the sector-specific labor importation schemes of the construction sector. The details are listed in the papers. We maintain close liaison with the Ministry of Commerce to reflect the latest situation of imported workers from the mainland. The ministry attaches a lot of importance to the employment rights of imported workers from the mainland. We will continue to enhance the mechanism for importation of mainland workers and protect the legal employment rights of mainland workers in Hong Kong. We adopt a multi-pronged approach to protect the employment rights of imported workers. My team and I are glad to take members' questions. Thank you. Thank you, Undersecretary. Members line up: Mr. Kenneth Lam, Professor Chen Wen-kong, Dr. Frank Yam, Mr. Chen Siu-chung, Mr. LUK Chung-hung, Mr. Lai Tong-kwong, Mr. Peter Shu, and Mr. KWOK Wai-keung. 4 minutes each, questions and answers included. Mr. Kenneth Lam, please. Thank you, Chairman. The current Trump government has put in place a lot of relaxation measures in relation to the importation of workers. These 2 to 3 years, we have seen a replenishment of the manpower pool for different sectors. We need to protect employment rights of imported workers. In the information papers, it is mentioned when imported workers come to Hong Kong within 8 weeks, they will have to undertake training as well as attend seminars. Can you let us know more about the contents and coverage of the briefing sessions? Apart from briefing sessions once or twice, do we have further training provided for imported workers? For money remittances, for example, imported workers may be caught by the law inadvertently. Can you provide more information to the imported workers in this regard? Not only employees, employers will also be caught by the law in some cases. So is it possible to provide more training to imported workers? Undersecretary. Thank you, Chairman. I'll give the floor to the Development Bureau and the Labor Department to supplement. Mr. Raymond Ho, Deputy Commissioner. Thank you, Chairman. Thank you, Member. According to the Standard Employment Contract (SEC), all employers are required to arrange for the imported workers to attend a briefing session within 8 weeks upon arrival in Hong Kong. The main contents are in relation to Standard Employment Contract labor laws of Hong Kong and the interests, rights, and protection that imported workers are entitled to. We also provide channels for making inquiries or complaints. There are also support schemes provided to imported workers. We welcome labor organizations to attend these briefing sessions. We brief these organizations on support services we provide. Development Bureau. Thank you. For the labor importation scheme for the construction sector, as Mr. Raymond Ho said, within 8 weeks upon arrival in Hong Kong, these imported workers will undertake training and attend briefing sessions. We emphasize employment rights and protection. Many imported workers reside in the dormitories we provide. They use literate book and online social media platform in the mainland. We provide information on literate book, for example. We drive home these messages and we remind imported workers repeatedly. There are also flyers to remind imported workers, and we'll continue with this line of work. Thank you. Any follow-up? No. Next, Professor Chen Wen-kong. Thank you, Chairman. I'm glad to see multi-pronged approach adopted by the administration to protect the employment rights of imported workers. I have some questions. In accordance with laws of Hong Kong, employers are only allowed to import workers from the mainland through 14 labor service enterprises. The network is some imported workers are charged a fee by these labor service enterprises. The employment rights of imported workers are at stake. There were also cases in which imported workers' wages were deducted. Regarding these phenomena, will the administration enhance collaboration with the mainland counterparts in order to protect the employment rights of imported workers? In paragraph 5, it is mentioned that labor inspectors of the Labor Department will carry out inspections having regard to the risk of non-compliance. Labor inspectors will also conduct interviews with imported workers individually. How many times of inspections? How many interviews? Any cases of exploitation of the employment rights of imported workers? Can the administration let us know more about these areas? When imported workers are treated unfairly, a report needs to be made. This is indeed good, but I'd like to know from the administration what measures are in place so that employers won't settle old scores with the imported workers when they file a complaint. Thank you. In relation to intermediaries, we require the 14 labor service enterprises to fill out a form when we have evidence showing that unreasonable charges or unreasonable fees are charged that is above the national requirement of 12.5%, complaints will have to be made. We aim to avoid or streamline the procedures. Among the 14 labor service enterprises, some provide information online, and interested parties can make an application through these recruitment advertisements online. 12 out of 14 labor service cooperation enterprises have their branch office in Hong Kong, so employers can get in touch with these enterprises directly. They don't really have to go through an intermediary to get in touch with the 14 labor service cooperation enterprises. When procedures are streamlined, the situation will improve. Regarding the number of inspections, I will give the floor to Mr. Simon Lee, Assistant Commissioner for Labor. Regarding inspections, labor inspectors have regard to the risk of non-compliance and carry out inspections of the workplaces as well as accommodation of imported workers. We conduct interviews with imported workers individually. If need be, we'll follow up on these matters. In 2024, labor inspectors carried out inspections totaling 4,417.
and also taking retaliation measures afterwards. If labor inspectors receive complaints during their inspections, there might be conflicts and they might have to go to the labor tribunal. And as a result, if the concerned worker is dismissed, then if there is no reasonable ground for dismissal, then the concerned party can also lodge a complaint, and we will take out investigation, and that will be done in accordance with the general or ordinary worker in Hong Kong in terms of their rights and entitlements. Well, just now you said that a total of 5,417 inspections were carried out. Were you able to identify cases of exploitation and so on? So Mr. Chen Wing-kwong would like to know more, I'm sure. Yes. Yes, thank you for your question. Well, when it comes to inspection, well, for general inspection, we noticed that the situation is that we have not identified specific non-compliance situations. And of course, in some cases, they may not have complied with the terms of the contract. For example, automatic bank transfers and so on. That would be a requirement under the SEC, and therefore we will have to remind the employer to make arrangements for the bank automatic transfers. Next, Mr. Ngan Man Yun. Thank you, Chairman. I have several inquiries. Well, to follow up on what Mr. Chen Wing-kwong just asked, with regard to the labor services enterprise as approved by the Ministry of Commerce, so what kind of publicity and education have you carried out in order to ensure that they would have to engage these labor services enterprises instead of other intermediaries? That's point number one. Second, all the imported workers from the mainland will have to come through these labor services enterprises. Can you make reference to the practice in Macau so that there would be a training ground? For example, right now it's set up in Zhuhai, and can they be trained in Shenzhen first so that they would first undergo the training courses that you referred to just now, so that they understand Hong Kong's laws and also the complaint procedures and so on before coming to Hong Kong, instead of reporting for duty with their employers in Hong Kong, and then they will have to take out time to undergo these training programs. And you also said that exploitation is a question of enforcement, and you talk about 5,417 inspections, but I'd like to know more about that. So how many prosecutions have you taken out of those inspections? Can I ask Ms. Catherine Law, Assistant Commissioner, to answer those questions first? Yes, thank you. Well, according to the current requirement, if the employer has engaged or imported workers from the mainland, then they will have to do so through the 14 licensed labor services enterprises to make the application and so on. And the list has been uploaded onto our website under the labor importation schemes. And for the 14 LSEs, if they've already got employment agencies in Hong Kong that work with them, those companies' names would also be uploaded onto our webpage so that they can also check out those companies. These are licensed employment agencies, so you'd be able to know exactly which agency would be entitled to help you with the importation of workers from the mainland. And also, what about the question of setting up a training base on the mainland? And also, do you have the prosecution figures? Chairman, well, on the training before employment on the mainland, we are now looking into that. So we are looking into the feasibility of doing so, but then that would take a bit more time. But then definitely after they have arrived in Hong Kong, they would definitely have to undergo the training within a very short space of time. And you also asked about enforcement figures. As we said, so some prosecutions have taken place, and we will see if we can identify more such cases. And in some cases, it's just non-compliance, not yet a breach of the law. Then we would also take out administrative sanctions. So we will also find out if they are also continuing to hire imported workers from the mainland. So through different levels and different actions, we will look at the level of breach to determine what kind of action will be necessary. What about education and publicity? Can the Labour Department do a bit more other than having the website for the employers to browse? Can you also take the initiative or take a preemptive strike so that for employers they would be alerted not to hire other intermediaries when it comes to hiring imported workers? And also, can the department coordinate so that there can be different tiers of enforcement action so that we can also be given the figures? Yes, you can also provide us the details in writing. It's not just about non-compliance. They might have breached certain regulations, and as a result of that, they would be barred from importing more workers from the mainland within a certain period of time. We would also like to know those figures. I'll ask the Labour Department to supply that afterwards. And in fact, other than the briefing sessions, we have been working with chambers of commerce, for example, together with Mr. Tommy Cheung. We have also had meetings with imported workers and also relevant bodies, and they have also asked questions and made inquiries because they'd also like to do so in a lawful manner. Next, Mr. Chow Siu Chung. Thank you, Chairman. I'd like the administration to explain a bit further to us because the reason why we are so concerned about labour interests and rights, because we are all in the same family, and therefore we hope that everybody coming to Hong Kong to work will be properly protected by law. And we are so serious about that. That's because while we are protecting the imported workers, we are also at the same time protecting local workers, because we don't want to see a situation whereby there would be unfair competition before imported workers and local workers. Because if employers can exploit imported workers, then of course they would all go for imported workers, and therefore the competition between local and imported workers would not be fair. And therefore we will also have to prevent exploitation, because that is also a means to protect local workers. And you talk about the 14 labour services enterprises because they have been approved by the Commerce Ministry, and therefore they are safe. But then very often they would also need to have some intermediaries to work in between, so that they can also be introduced some of these interested parties and so on. And therefore employers who would like to import workers, given the fact that they know that they have been given certain quota by the administration, then they would also work through some of these intermediaries. They might be unscrupulous, and therefore they might be able to say, well, can I get the workers so that I do not have to pay the standard pay, and then I would be prepared to give you a kickback of say $5,000 each. And if that is the case, then there would be exploitation of imported workers, because somebody is pocketing some of these money or funds. So can you tackle those problems by targeting these unscrupulous intermediaries? And the Development Bureau has also introduced a number of measures, and I do appreciate that. And definitely, I think they will help. But then in terms of regulating the agencies and so on, it's not just for the construction sector, because there are other trades, for example, the care workers, and also even under the supplementary labour importation scheme, we would also have to regulate the agencies which would be involved in importing workers. So have you also considered whether or not it's necessary to extend it to other sectors, so that you can introduce something similar to the labour services enterprises under the scheme for the construction sector? Yes. What I'd like to say is that whatever scheme that we are talking about, even for the supplementary labour importation scheme, the ultimate responsibility has to be shouldered by the employers. Because if somebody tried to advise the employers to exploit workers, and in the end, if they agree, then it would be them who would be held responsible at the end of the day. and therefore they cannot just shirk the responsibility by saying that somebody has coerced them into doing certain things, and therefore they would not be subject to the punishment of the law. I hope that the employers would also have to understand their own responsibilities. Whoever they have hired, the intermediaries are just there to help, and therefore they will have to take up the ultimate responsibility or liabilities in that case. And therefore, I will defer to the Development Bureau, which will supplement, because ultimately the employers will have to be held responsible, even though they might have worked through agencies or labor services enterprises. I'll defer to my colleague. Yes, thank you, Mr. Chow. As the Undersecretary has said, for the supplementary labor importation scheme for the construction sector, whether it's the principal contractor or the subcontractor, they will have to understand what they are required to do under the law. They cannot just pass all the buck to the employment agencies. And for the cases that you just referred to, well, basically, we have noticed that for the principal contractor or the subcontractors, they might have used the intermediaries, and then it's the intermediaries that might have breached the requirements. But then we have gone one step further, so that for the agencies, you will have to make sure that they would comply with all our requirements. The agencies would also have to sign an undertaking with us, so that where they have signed the undertakings, if they have breached the law, then we will be able to go after them. And very often what we find with these agencies are, well, when they organize lunch boxes and also transportation and so on, they might have confused their roles. And therefore, when it comes to charging for these services, there might have been confusion. And therefore, if you're helping the employers to make sure that the workers would be able to report for duty on a daily basis, then you must not charge the workers, and therefore there should be no payment of fees by the workers. And if you have to arrange for accommodation, transportation, and meals and so on, other parties should be engaged. So all the agencies will be required to sign such an undertaking. And if we notice that there are some unscrupulous practices and so on in accordance with the undertakings, then we can take enforcement action against these agencies. So that would also serve or have some deterrent effect on these agencies. We have also made it clear to all the agencies concerned, and for the Development Bureau would like to adopt a more targeted approach, and also the number of workers involved in the construction sector is also relatively large, and therefore we will have to be more meticulous when it comes to law enforcement. Yes, that has been explicitly provided for in a paper, but then Mr. Chow is concerned that there are other agencies that might be involved in imported workers schemes, and there are agencies who might not be fully aware of the requirements, and other sectors might also be involved, and therefore he'd like to know more about this. Yes, Undersecretary, your mic has not been switched on. Your mic is not on. Yes. Well, the Development Bureau's practice will be something that we will refer to. And in terms of the numbers, many employers might not be engaging agencies if they are just importing a dozen or so such workers. And therefore, if the number is large, then we will be monitoring closely as to what they do. Next, Mr. LUK Chung-hung. Yes, I'd like to declare interest because I belong to the FTU, which has been commissioned by the administration to organize this imported workers support scheme. So for imported workers being exploited, I think that's very common. Well, we have received a total of some 30 reports with their names attached. And in fact, that's just the tip of the iceberg. In fact, imported workers being exploited is quite enormous. And the situation is really alarming because if you don't accept such exploitation, then you would not be able to come to Hong Kong to work. So it's as serious as that. And why has that been the case? Mr. Chen Wing-Kwong has already referred to this. That is, they are also concerned about retaliation afterwards. So if they dare to lodge complaints, in fact, they would have the score settled right away if they dare to lodge complaints, because they might be dismissed on unreasonable grounds. You might have said that there would be proper legal protection if they lodge complaints. In fact, as soon as they raise their hand, they would immediately be fired the next day. So they'd immediately be repatriated the next day. Even if they are not lodging a complaint, if they just refuse to be exploited, then right away they'd be dismissed. So given the situation, I think the whole system warrants further attention. There are two core issues. First, in terms of inspection, is it effective?
Well, some workers send me screen caps saying that they shouldn't say anything improper to the Labor Department when the Labor Department is carrying out inspections. The ICAC will have to look into this matter. After workers make a complaint, they may lose their job. The Undersecretary is very passionate about helping imported workers. Mr. Ho helped the worker to look for a job. But no matter how passionate Mr. Ho is, it's difficult for Mr. Ho to look for jobs for every single imported worker. Imported workers will have to return to the mainland and wait for a certain period of time before they can apply again. Who will make a complaint if the imported worker needs to wait for a period of time before they can apply again? The complaints I made are only the tip of the iceberg. Regarding accommodation when the problems have been solved, so how can you look for a job for the worker again? How can we look for a job for the worker who has lodged a complaint? That is the crux of the matter. Undersecretary. Thank you, Chairman. Thank you, Mr. Luk, for your question. It's indeed difficult for a worker to look for another job immediately. There are quotas for some companies, and they may have candidates that they want to engage. They may be training some candidates in Guangxi, for example, and they want to take on those workers. So it's actually difficult to ask a company not to engage candidates that they have been training for. With more candidates, is there any other method? Well, we'll have to look into it. Like other workers, if a worker is dismissed by a company, we can seek compensations for the worker who has been laid off or fired by a company through law or through the courts. Even for a local worker, we don't find a job for a local worker who has been dismissed either, so we'll have to see how we can make enhancements in the future. Well, for local workers, they can simply turn to another company, but for imported workers, they'll have to go through an intermediary. It's actually not that difficult. For imported worker intermediary, that is the labor service enterprise, they charge 12.5%, and they have to provide services. They introduce a job to a worker who has been exploited. Well, honestly, all jobs exploit their imported workers, so to speak. Even if you are not going to help the worker to find another job instantly, can you help them look for a job faster? Well, exploitation of the employment rights of imported workers will affect the local employment market. So why don't you simply look for a job or help imported workers to find a job? If there are no complaints, does it mean that you don't have to do anything? Well, I'm indeed enraged. Please give the floor to the Undersecretary to give you a response. Any tip-off before the labor inspections? Are the labor inspections effective? Well, I'd like to clarify. All inspections are anonymous. They aren't planned. They are spot checks. For all the inspections, they are surprise checks and they are anonymous checks. Well, there are actually many complaints, not just one single complaint. Alright, the Undersecretary has already answered. Next member, Mr. Lai Tong-kwok. Or maybe in the second round, Mr. Luk. I'll let other members speak first. Mr. Lai. For deduction of wages, did all these workers attend your briefing sessions? Undersecretary. Chairman. Yes. Yes. Workers will have to attend briefing sessions within 8 weeks after their arrival in Hong Kong. So the problem is, why aren't they aware? Even after attending the briefing sessions, are these briefing sessions effective? Do they achieve the intended result? Well, I'd like to have a copy of the briefing session. Please provide it for our reference. I'd like to know what is covered in the briefing sessions. Do workers simply need to sign? Do they have any takeaways from the briefing sessions? When an imported worker goes to a new place, of course, they know nothing about the rules or the laws of a place. They only have the rules or the rights they have in their own country. The rights and protection might be different, so we need to let them know clearly what employment rights and protection they have. Otherwise, what is the use of these briefing sessions? Such a labor protection mechanism has been in place for a long time. We have Supplementary Labor Scheme SLS, but exploitation of labor of imported workers still remains. They always have a plan to outwit you. When they have a good idea of your system, then they find loopholes to exploit. So you need to implement effective publicity. The purpose is to let workers know clearly what employment protection they have, what rights are they entitled to. Well, I'm not saying that we just need to help imported workers. We need to help local workers as well. Above all, we need to help the administration to implement this scheme. We have a shortage of manpower. That's exactly why we need to import workers from elsewhere. When there is exploitation, that means the scheme isn't effective, and it is the whole society that will suffer in the long run. Not just imported workers, but also local workers in the local job market. So when you work on the scheme, you need to review the contents to make sure the purpose of the briefing sessions is achieved. You need to ensure your policies and your measures are effective. Say, if this mechanism isn't isn't deterrent enough, you can criminalize these acts. You don't necessarily have to resort to existing legislation. The Development Bureau is relying on administrative methods or administrative means. It is not enough to just take remedial measures after an incident has happened. And the Secretary, thank you, Mr. Lai, for his views. The administrative sanctions aren't just about the protection of employment rights of imported workers. It concerns tendering exercises as well. Apart from implementing administrative sanctions, we will see what other measures we can put in place to enhance the Supplementary Labor Scheme SLS. Thank you, Mr. Lai. We will look into the situation. Thank you. Next, Mr. Peter Schill. Thank you, Chairman. I heard from many members imported workers seem to be exploited. Does it mean in relation to their income? When imported workers come to Hong Kong to work, employers pay imported workers by depositing the money directly into the Hong Kong account or their account in mainland or through those labor service enterprises. And the Secretary, well, usually exploitation takes place in relation to the income of imported workers. We require employers to open a bank account for imported workers as soon as possible. The wages of imported workers have to be deposited to the bank account of imported workers by automatic payment. In case of meal charges or mandatory transportation fees, as we have already mentioned, employers or service providers shouldn't provide meals or transportation to imported workers at the same time. We want to prevent these situations. Mr. Peter Schill, well, in other words, employers pay imported workers directly. They know clearly how much they need to pay workers. They have a record. So they can simply check the salary receipt. When the figures don't tally, then we can already prosecute these employers. Why couldn't we take out prosecution? You can simply check the figures to see whether they tally or not. Well, yes, indeed, we can check the salary receipts. Employers and employees may have some agreements. Employees may think that they are forced by employers to do so, to take out a certain portion of their wages. Mr. Peter Schill, well, why are employees willing to give a certain amount of wages back to the employers? Why would they be willing to do so? Well, that concerns individual agreement between employers and employees, and that's a complaint we received. And it's actually quite difficult for us to escalate the level to a criminal level. When employees receive an amount of money and then they give back a certain part of their wages to the employers, that may be down to the agreements made between employers and employees. Even when, well, that actually means employees are willing to come to Hong Kong to work even if they receive a lesser amount of money. That means these imported workers are willing to accept a salary lower than the prevailing median monthly wage of a comparable position in the market. That means this amount of money is already higher than the amount of money they receive in their place of origin. They receive more than they would have received in their own country or place of origin. That is exactly the situation, but why would they be willing to do so? That is because the wages offered to these imported workers are higher than they would have received in their own place of origin. So what is the problem? The problem lies in the prevailing median monthly wage. Why do we set it so high instead of protecting local workers? We need to enhance local productivity. Imported workers are willing to be exploited, and even so, they are still willing to come to Hong Kong. Intermediaries pocket the money. They pocket the difference. Tobacco duty, it's so high for 2 years. The number of smoking population remains the same, so the difference of the money actually goes to the illicit market or illicit tobacco market. We want to import labor to come to Hong Kong to help with local manpower situation, but then we need to protect their employment rights. The difference in the money actually goes to the intermediaries. The median monthly wage in Hong Kong is affecting our competitiveness.
Undersecretary. Thank you, Mr. Shiu. We will go back and take a look. Next, Mr. KWOK Wai-keung. Thank you, Chairman. Let me declare interest first. I belong to the FTU, and the FTU has undertaken the imported workers support scheme. So our policy is to protect local workers' job opportunities, and that's the first and foremost priority. And the reason why we have to use the market prevailing median wage for these imported workers, that's to prevent a situation whereby the employers would be over-relying on imported workers. Does that mean that if we set that at a high level, there will be exploitation inevitably? Well, apparently that's the case, and therefore the department and the bureaus will have to come up with more measures to prevent this from happening, because if the pay is set at a high level, then there might be loopholes that people can plug into and pocket some of the money. But we are also concerned that in the event that there are problems, how would that be dealt with? Well, just now Mr. Lai Chong-kwok made a very good point. You have the briefing sessions, and then imported workers theoretically should have known their rights and entitlements, and still they are prepared to swallow some of these exploitations. Why? Apparently, some of the intermediaries or the go-betweens might have told them that when they process their applications, they have already done some brainwashing. They might have been told that this has been a practice in a trade, and therefore you will have to have this deducted and that deducted and so on. This is something that we need to prevent from happening, because Mr. LUK Chung-hung also talked about the case whereby the healthcare worker was exploited, and I was also there to help. So indeed, some of these caretakers or carers, they were aware of their entitlements. Still, many of them would be prepared to swallow them instead of coming forward to report the cases. And in fact, the residential care homes have also taken some measures to prevent this from happening again. But then the problem still remains, because there are some mainland agencies that are problematic. That's the reason why we have these problems. Or is it there are some people who try to manipulate these agencies, and they're actually pocketing some of the benefits or profits? And second, if they want to report such exploitations, they will have to go back to the mainland first, and as a result, the service fees that they have paid would go down the drains, and therefore you will have to make sure that if they report the cases, they would also suffer losses. You will have to make sure that that will not happen. And thirdly, as the paper set out, the employer would have to sign the undertaking, and therefore if something untoward happens, they would also have to be held liable. That is, of course, correct, because an employer would also have to be involved in monitoring the situation so that such things will not happen. And I'd also like to know whether or not you have checked with mainland authorities, because for mainland agencies or go-betweens, well, in theory, they are there to serve the labor services enterprises, but then can they just claim that they have no idea as to what is happening and therefore they would not be held liable? So you would also have to make sure that LSEs on the mainland would also be aware of their duties, and therefore they cannot shirk their responsibilities to other third parties. Yes, I think we have already been to Beijing to talk to the Ministry of Commerce on several occasions to sort out these matters. Well, you talk about the go-betweens or the agencies on the mainland. We are not fully aware of the relationship between them and the LSEs. But then if intermediaries are involved and if they are hired by the labor services enterprises, then of course we will convey those to the Ministry of Commerce so that they would also be able to go after these employment agencies to make sure that LSEs would engage only the authorized agencies when it comes to making such applications and so on. Now it's my turn. Well, I understand that the Development Bureau has rolled out 4 measures, and of course I don't want to see a situation whereby after the investigation the so-called agencies would be colluding with employers or that they are working with employers to exploit these imported workers. We don't want to see that happen. But then, as you say, the agencies will also have to sign undertakings, and they will also have to make pledges as to what they're going to do. And yet, the agencies are not the employers. And therefore, if they ask the imported workers to give them kickbacks, given the fact that they are not employers, and therefore there is no way that they would be found to have breached the employment ordinance, then have they broken the law? And through what measures are you able to punish them? That's my first question. That's about the agencies. Second, I would also like you to look into this in greater detail. That is, for other sectors, do they also have a similar system of agencies? You said that in some sectors they are importing a smaller number of imported workers, and therefore they do not need to engage agencies, so to speak. But then if other sectors are also having the same practice, I don't think we should wait until after there are problems involving the exploitation of imported workers. So I think they might think that with such a system in place is not bad at all, because that might help. So you will also have to look into the situation to find out if other sectors are also doing the same by engaging agencies to help with the importation of workers, and also in the performance evaluation, if they have breached the rules previously, that would also be reflected in the evaluation. All right, if workers come forward to report the situation, then agencies or contractors involved would also have their applications affected. They might be suspended from lodging new applications. So can you tell us more about that? Yes, thank you. Well, we refer to the intermediaries. Well, you're correct in the sense that intermediaries are engaged by the employers, and of course the employers also have the duty to make sure that agencies would be signing that undertaking, so that the agencies would also have to comply with Hong Kong laws. So that would provide a basis for taking action against the agencies. And secondly, if the agencies are actually taking the workers to work on a daily basis, then they should not be charging the workers. And when we take enforcement action. All right, if there are complaints about these agencies and if they are found to have done that, for example, if they have charged the imported workers for accommodation, transportation, and meals and so on, then they would have breached the relevant contract. Or else, without the undertakings, we would find it difficult to take enforcement action against them. And for other agencies, if they charge miscellaneous fees, for example, transportation and meal charge and so on, the fee will have to be transparent. And through the principal contractor, we would also check how much they are charging the workers. So we will have to find out what they are charging the workers, and then the workers should have the choice of not taking up those services or offers. And also for the works departments concerned, if we find out that there are breaches or irregularities, then they might be suspended from making applications within a certain period of time. And if they put in bids, their chance would also be affected. And I understand that works departments would be more than happy to echo this practice, because they'd like to make sure that no irregularities would be found. Some members would like to speak for the second time. We have another item for discussion, and therefore time is quite pressed. And therefore, I'll give each of you 2 minutes. First, Mr. LUK Chung-hung. Thank you, Chairman. First of all, I'd like to respond to an earlier point. For the exploited workers, overwhelming majority of them have not done so on a voluntary basis. Well, some members said that they are willing to take up a lower pay and so on. Well, actually, some workers wonder why they have to have this and that deducted from their wages and so on. Well, the supplementary labor importation scheme is to help the workers. It's not for the purpose of saving manpower cost, and therefore, if they have their wages suppressed, then that would be against the principle of having high quality development and also new quality productivity and so on. So on that basis, I'd like to make 3 points. First, can the Bureau emphasize this with the mainland authorities? That is, for the 14 LSEs, they should be banned from engaging intermediaries to help with such schemes. They complain that they have difficulty finding workers and so on. In fact, on the mainland, I think the situation is such that there should be no difficulty in hiring workers, because if you put out the advertisements, they have an overflow of manpower. So definitely there would be many people who would be prepared to apply. So why do we have to do so through the labor services enterprises? Because there are a lot of unscrupulous practices. And also, what's the role of trade unions? Well, for Hong Kong trade unions, we will have to work with mainland trade unions, and before the imported workers come to Hong Kong, the mainland trade unions will have to contact them first, so that there would be regular contact with these imported workers. So that would also enable us to register some of these workers so that we can have better contact with these workers. That would also be a good chance for us. And thirdly, if we are sure about certain cases, then the contractors involved would not just be suspended from making application for importing workers. They should be banned from putting in bids or joining any tender exercise for local projects. I think only then would we be able to achieve a deterrent effect. Well, all those are put in place already. What about the first two practices? That is to ban them from bidding for government projects. So what about the first two suggestions? Yes, they will be banned from bidding for government projects. What about the 14 LSEs? They should be banned from engaging intermediaries. And also, what about the roles of trade unions? We have taken on board your views. We will consider them. Yes, please consider them. Next, Mr. Siu Ka-fai. Thank you. For the 14 LSEs, my understanding is that they are on the mainland, and they are authorized agencies on the mainland, and they will also have to get someone to help them with contacting these workers, unless you require them by law to set up subsidiaries to do the job. If they have to get multinationals to be involved, definitely they will have to engage someone to help them. Or else, if I'd like to do something in the Philippines or in Africa, I will also have to set up a local company to do the job. So I think that's necessary. And if their business is good, then of course they'll set up a company to do the job. So I think it's only reasonable for them to engage agencies as to whether or not the agencies would be able to get other business. Well, that's the way of collaboration. So why should I be prevented from getting business from elsewhere? So in between, if they have profits, then of course they'll do it. So if you ask me to help, then of course I'll be prepared to help if I get some benefits, and therefore a lot of benefits or profits will be involved. And as a result, many people would try to have a hand in that. And just now, Mr. Luk Chung-hung was saying that if that friend wants to come to Hong Kong, there might not have been any agreement and so on. Well, just use your common sense. If you're paid $20,000 and I would be prepared to pay you $10,000 if you rob me once a month, then I would definitely have reported your case to the police, because on the mainland they're only pay $4,000, and if they can get $10,000 in Hong Kong, then of course they'll be happy to take that offer.
As Mr. KWOK Wai-keung said, the median monthly wage in Singapore, the situation is quite different. They have the highest salary in Asia. Their competitiveness has been enhanced. For domestic helpers in Hong Kong, they're earning $4,999 per month. We need to have a clear picture of the whole situation. Mr. Lai Tong Kwok, I'd like to ask the Development Bureau. You said that intermediaries need to sign an undertaking. In case of non-compliance, prosecution actions would be taken. So what laws do they violate? Development Bureau. Indeed, intermediaries aren't employers, so we don't invoke the employment ordinance. Well, as I mentioned, principal contractors have already paid the intermediaries, so intermediaries shouldn't charge the imported workers. And this is one direction that law enforcement agencies can take. Law enforcement agencies will collect evidence, and whether they have sufficient evidence is all down to their evidence collection. Say meal charges, they need to be more transparent. Is it possible to provide information to law enforcement agencies in relation to some procedures through existing laws with sufficient evidence? Then law enforcement agencies can follow up on the cases from the perspective of fraud and so on. Unless it is a formal oath, then you can take out prosecution action. But how can you prove exploitation? Well, I think you'll have to think again. What legal basis do you have? Otherwise, it's actually very difficult for you to achieve your purpose if you lack a sound legal basis. Well, this is our first step. We have liaised with law enforcement agencies. They think that this could be of help. But I agree with Mr. Lai. We'll discuss with the law enforcement agencies to identify more room for improvement. All members have already spoken on this issue. I hope the administration has already heard members' views. Imported workers come to Hong Kong for a better living and for a better income. At least we need to provide protection for these imported workers. We hope the administration could fare better in this regard. Thank you. Moving on to agenda item number 4, improving the trade union regulatory regime. Let's invite the administration to join us. This agenda item relates to a legislative proposal, so all members of the Legislative Council are invited to join the discussion of this agenda item. We have with us Mr. Chris Sun, Secretary for Labor and Welfare, Mr. Raymond Ho, Deputy Commissioner for Labor, Ms. Christine Butt, Registrar for Trade Unions from the LD, and Ms. Kenny Zhang, Senior Labor Officer, Trade Unions from the LD as well. Welcome. Members who'd like to speak, please press the button to do so. I now give the floor to Mr. Chris Sun to walk us through the papers. Thank you. Good morning, Chairman. Good morning, members. This paper is about improving the trade union regulatory regime. This is very important. It is key to safeguarding national security. I believe members understand this legislative amendment enables us to safeguard national security, thus fulfilling our responsibilities. The government proposed to amend the Trade Unions Ordinance, TUO, to enhance the protection of national security on the one hand, and on the other hand, improve the regulatory regime for trade unions as well. The details have been provided in Annex 1 and Annex 2. Annex 1 is in relation to the proposed amendments relating to safeguarding national security, and Annex 2 concerns other proposed amendments for improving the trade union regulatory regime. In accordance with the National Security Ordinance, the Hong Kong government needs to manage and advertise all matters that safeguard national security. The functions of the Registrar of Trade Unions cover the responsibility for safeguarding national security. In discharging its function, the Registrar must put national security first, and according to this factor, due consideration needs to be given. We have considered a handful of main points. 1. We need to be in line with the local situation of trade unions. And we also need to tally with local legislation, that is the Safeguarding National Security Ordinance as well as other pieces of legislation. We also need to protect freedom to join association and so on. However, members need to understand such freedoms, that is the right to freedom of association, is not absolute or unrestricted. So we consider these 4 sectors all at once, hence our legislative amendments this time round. The details of the amendments are detailed in the information papers. My team and I are more than willing to take members' questions. I'd like to give more time for members to ask questions. Thank you, Secretary. A total of 6 members have pressed the button. The lineup is Ms. Lilian Kwok, Mr. Kingsley Wong, Professor Chow Wen Kwong, Mr. Chow Siu Chung, Mr. Lai Tong Kwok, and myself. 4 minutes each. Questions and answers included. First member, Ms. Lilian Kwok. Thank you, Chairman. Regarding the legislative amendments, I think they are necessary. We have the legislation exercise for Article 23 as well as for national security law. In society, all that take place shouldn't be against the national security ordinance. What we do aims at improving the healthy development of the local trade unions. So whatever they do, it shouldn't be flouting the Safeguarding National Security Ordinance. Even if we put in place these legislative amendments, they won't have any impact on trade unions in Hong Kong unless they have not quite right mindset. Otherwise, the impact will be minimal. On receiving funds from overseas jurisdictions, there are provisions in the legislative amendments. If we need to export funds to organizations of an external place, is there any regulatory regime regarding the development of trade unions? From 1971, this ordinance came into operation. In 1998 or 2000, there were updates. A total of 1,400 or so trade unions, as I can see from the information papers. Out of a total of 1,400 TUs, how do you manage or supervise these TUs? Are there any vampire TUs, so to speak, or inactive TUs, or in case of any unhealthy development or unhealthy operation, how are you going to handle these inactive TUs? Secretary. Thank you, Chairman. Thank you, Ms. Lillian Kwok. First of all, thank you, Ms. Kwok, for your support. And I'll give the floor to Ms. Butt, Registrar of Trade Unions. Legislative amendments concern receiving out of Hong Kong funds. For local TUs, if they want to export the funds to support the operation of organizations of an external place, there is regulation under the existing ordinance. So we don't find it necessary to amend legislation to cover it. Among the 1,400 or so TUs in Hong Kong, some aren't really vampire TUs, so to speak. That is a colloquial term. They are actually inactive TUs. And they are managed and regulated well under the existing legislation. I'd like to give the floor to the registrar to tell you what measures we are putting in place in relation to these inactive TUs. Registrar. Thank you, Ms. Lillian Kwok, for your questions. Regarding your first question, as for the funds of TUs, under Section 33, brackets 1, brackets J of the TUO, the provision of any donations or funds to organizations of an external place, approval has to be sought from the Chief Executive. Regarding inactive TUs, the existing TUO Trade Unions Ordinance has some provisions. When a TU ceases to be in operation, the registrar can cancel the registration of the TU concerned, but will have to review all the factors concerned to ascertain the fact that the TU no longer exists. Say whether they still have a committee, the membership, any accounts they submit. All these are factors we take into account. We look into the situation before we make a decision regarding these inactive TUs. Some TUs may be quieter. For a short period of time, they don't have a committee, but afterwards, they do have they do have a committee. The cancellation of registration is a serious decision, so we'll have to follow up after serious consideration. For inactive TUs, they have been formed for a long time. The chairperson might have already passed away. These TUs might not have held any meeting for a long time, but there are still members within these TUs. There are a total of 1,400 TUs or so in Hong Kong. Will you review the situation, look into the situation, so the TUs will play a better role in the industry? Thank you.
希望局長可以。
Okay, so Secretary, please do consider that. Next, Mr. Kingsley Wong. Yes, thank you, Chairman. We support the SL government in making the amendments because in the past we can see that during the black-clad violence, some 5,000 trade unions applied for registration within a 6-month period, and some of them have actually been set up, and as a result, they might have organized activities that might be law compliant on the face, but then they might be publicizing the message of calling for strikes and so on, and that's why they should have their registration cancelled, and therefore we will have to plug the legal loopholes in order to prevent anything that would be prejudicial to national security. We would also like to prevent people from making use of this system to endanger national security, and some of these trade unions might be working properly, and yet they might have been taken or made use of by other unscrupulous parties endangering national security, and therefore we have to make sure that something can be done about them. So it's like the Security Bureau preventing people from registering as societies and so on. And therefore, we'd also like to know whether or not you can do the same, because you don't have the manpower from the Security Bureau to help. So how can you be sure that trade unions are not infiltrated by these elements who try to endanger national security? And also, Hong Kong is a metropolis, and therefore we also have to maintain contacts with our overseas counterparts, and therefore we have to connect with the mainland as well as other places and Macau. So it's not a problem when we maintain communication with our overseas counterparts, but then we may not have any idea as to what is behind them, and therefore when we engage in trade union activities, how can we be sure that we would not be inadvertently breaking the law, or that we would not be subject to external places' influence? And even if you have a good piece of law in place, you would also have to ensure that you can enforce it properly, because we have been told that some trade unions have complained about poor enforcement, because some trade unions might have advocated strikes, or they might have been involved in black-clad violence, and some might have been registered, and yet even after the law has been enacted, they might still have held elections that might not be entirely lawful, and some might even have failed candidates to take part in elections. For example, in November 2020, I understand that some trade unions have actually put up protests against what you did, and therefore, how are you able to enforce the law in order to safeguard national security? Secretary. Yes, I'm grateful to Mr. Kingsley Wong for his support for the proposed amendments. I think the issue is whether or not the registrar has appropriate powers, and secondly, is he able to make important decisions under the law? Well, first, by the amendment, the registrar would be given additional powers, and that's done after careful consideration, because we understand that the registrar would be appointed by the chief executive, and therefore his powers come from the chief executive. That's very clear. And therefore, in deciding on how to use or exercise its powers, he will have to do so very carefully. That's point number one. And secondly, when it comes to national security, it's not just for one bureau, one department to decide. Within the government, we have a comprehensive system in place to deal with any issues relating to national security, and there has to be sufficient evidence to support the case. And therefore, when the registrar is trying to exercise its powers to approve or to cancel the registration of a trade union, he will have to do so very carefully. That's to ensure that our trade union system will be able to reflect the importance of national security. That's the first point to consider. Secondly, you can also make reference to international labor organizations, conventions, and so on. In attending such conferences, you will not be affected. First, if you receive funds from external places, then there is a clear provision as to whether or not you are permitted to do so. And if you are affiliated to them, there are also clear provisions about them. Or if you assume office with these organizations, then there are also clear rules. So if there are international conventions whereby several thousand people might have taken part, and if you just shake hands with some of these people, whether or not you would be breaking or breaching national security requirements, you can be rest assured that that would not be the case. Precisely because we had a painful experience during the Black Clad violence. As you might recall, within a space of several months, we received several thousand applications to register as trade unions, and many of them are not genuine cases. Many of them would just like to make use of the registration system, and they like to take advantage of the loopholes. They might be involved in something that has nothing to do with trade union activities, but then because of the previous legislation, we might not have been able to do anything to protect the proper functioning of our trade unions and also ensure that national security would not be threatened. By this amendment, we will be able to do so. So the chaotic situation that happened in the past would no longer be able to happen. If that should happen, then the registrar would be able to nip the problem in the budding phase, and therefore a lot of work will have to be done by the registrar. Next, Mr. Chen Wing-kwong, thank you. I welcome the administration's initiative to make amendments to the trade union regulatory regime in order to improve or perfect the system so that people will no longer be able to make use of trade unions as a front and engage in activities that would threaten national security. But then I have two questions. First, I noticed that in the amendment, many areas will be involved. So I'd like to know, in the past, how you're able to explain these very clearly to trade unions as well as the public so that they would all know the purpose of the amendment that would not affect the setting up of trade unions, and in fact that would also enable trade unions as well as the public to understand the law better and comply with the relevant requirements more properly. And also secondly, for people endangering national security, on the date of their conviction, they will no longer be allowed to assume office in any trade unions or apply to become the promoter of any newly set up trade unions. I support that. But then I'd like to further clarify that for offences of endangering national security, if they have been charged, will they be able to become advisors or member of trade unions? And if the answer is in the positive, then how can you be sure that they would not be usurping the powers of the trade union and then make trouble? And also, how can you prevent them from becoming a member of a political organization or body of external places? For example, there are some organizations that might be set up under the name of environmental protection in external places. Then how can you be sure that they would not be inadvertently caught in such situations? Thank you. Thank you for your support, Mr. Chen Wing-kwong. Point number one, explanation is very important. And therefore, the first step that we have to do is to come to this panel to explain in detail as to the proposals for amendments. I'm sure all the trade union friends will be reading that paper very carefully. And next, we will be submitting the amendment bill to the LUK for scrutiny, and then it will not come into effect right away because we will need time to explain to the public as well as trade unions. We will have to do a lot of education and publicity. In particular, looking at the day-to-day operation of trade unions, there might be areas that they are concerned about, and we will have to explain to them very carefully because for any good piece of legislation to be effective, explanation and publicity is very important. And for those who have been convicted of national security offenses, they would never be allowed to take up offices in trade unions because officers of trade unions have actual powers, and therefore, if they have been committed of offenses under the national security law, then they should not be allowed to take up such positions. But then it doesn't mean that they will be banned forever. And therefore, under the Basic Law, under the Bill of Rights Ordinance, and under international rights conventions, they have the freedom of association, and therefore they can still be involved in trade union works. They can become members because they will be able to enjoy the benefits and so on. But then they could not assume office of the trade unions. That's a matter of principle, and that's very important. And thirdly, you might be concerned that, well, I'm not sure whether or not that organization is problematic because on the face of it, it has nothing to do with political organizations and so on. But then if I am involved in their work, then I might have breached the law inadvertently. But then, well, you will have to send someone into that organization and assume office of that organization before you will be committing an offense. If you just shake hands, if you just meet with them on one or two occasions, then of course that would not be against the law. And therefore, if you have any association with any external places, organizations, then you will have to be extremely careful. If you have any concerns, then you can also check with the registrar, because we do have inquiry services available, and therefore it's better to play safe than sorry. And therefore, as a member of our society, trade unions play a very important role, and therefore you will also have to discharge your duty under the national security regime. Yes? What I'm concerned about is that they can be members, but what about advisors? Can they be consultants of trade unions? So it depends on whether or not such advisors would be officers of that trade unions. You cannot become an officer or an executive of the trade union. If they just call you an advisor without any powers, then I can say that that would not be covered, because the nomenclature is not important. By whatever name you call them, it's not important. But then if you're assuming office of that trade unions, then of course that would not be permitted. I will have to make that clear. Because, well, for advisors, they may be playing a very important role in trade unions. They could almost manipulate how the trade union functions. So basically, they are very influential. That's the reason why I'm so concerned about this. That's the reason why I'm asking whether or not they can become advisors of the trade unions, because I'm concerned that they might be having undue influence over the trade unions. They might be hijacking the trade unions for their own purposes. Well, a trade union has the duty to uphold national security, and for someone who has been convicted of national security offense to become an advisor of that trade union, well, if they allow that to happen, then of course they cannot shirk their responsibility. So you have many choices, and if you have to engage someone who has been convicted of national security offenses to be your advisor, then we will also have to find out whether or not your trade union is problematic. You will have to look at the amendment in its totality. You cannot just take something out of its context. Well, I understand that, but then it's about whether or not it's been made very clear under the national security law. And that's why I would like to find out. Yes, I think the Secretary has already made it clear. That is, the post title is not important. It's about whether or not that person can control the functioning of the trade union. That's a matter of principle. Next, Mr. Chow Siu-tung.
我相信
Thank you, Chairman. I believe all of us have vivid memory of what happened in 2019. There were a lot of trade union applications or registration back then. While some TUs staged political strikes that aren't consistent with their constitutions. I support the administration's proposals to improve the trade union regulatory regime to safeguard national security. I have deep feelings as well. In a short period of time, there were thousands of applications for registration of TUs. So what about the operation of normal TUs? How could they sustain their operation? How could the ordinary TUs still be able to operate? In the long run, we need to enable the healthy development of trade unions in Hong Kong. When a TU receives funds from an organization outside Hong Kong, would that cause any problem? Now, with legislative amendment, there's a solution. That is, you need to make a declaration and that will allow the healthy development of local trade unions. I'd like to ask the Secretary some questions about implementation. Regarding details of implementation, how can we minimize the control over trade unions while protecting or safeguarding national security and improving the TU regulatory regime? First of all, we request TUs keep a record for 2 years. There is no such requirement under the law. There is no requirement as to keeping minutes either, and that would cause difficulty. Can we prepare a form listing what should be contained in the minutes? Can we provide such templates to TUs? Regarding participation in organization of an external place by committee members of TUs, under existing legislation, there is no legal requirement to make any declaration. Some TU members in Hong Kong have capacity in organizations of an external place. Are these legislative amendments retrospective? Do existing TU members need to report or declare as soon as possible? Some TU members may be members of international trade unions. If they have already made a report to the Labor Department, someday, if an international trade union may be defined by the government as a political organization because of probably other acts, in such a case, does the administration have a mechanism to handle these matters? That is, when an international TU has already changed to a political TU, what can local TUs do in order not to break the law inadvertently? What can they do? Secretary, 3 questions. Thank you, Mr. Chow. Once again, I thank Mr. Chow for your support. 3 questions. Well, let me start with the simplest one. We have 1,400 or so trade unions, some larger, some smaller. We understand for some smaller TUs, their capabilities might not be as good, and I understand they may not be so good at preparing minutes. We do have existing measures to help these smaller TUs to help them prepare for minutes. Say what resolution, what items have been discussed. We have forms. We have these templates for smaller TUs. We also have transitional provisions. I can ask the registrar to give you more information regarding your second question. For organizations which are international trade unions, what can local TUs do if these international TUs have changed to a political organization? Well, indeed, a trade union may be a normal trade union or an ordinary trade union today, but when they become a political organization someday, what can trade unions do? We have all the record. If a TU has changed and has become a political organization, we already have a mechanism for local TUs to report to the government. Local TUs won't be left in the dark. Simply put, you can simply withdraw from the international TU which has become a political organization. Registrar, regarding transitional provisions, we are still drafting the legislation at full steam. Just now, Mr. Chow mentioned for some staff members of TUs, they may be officers of an organization out of Hong Kong. Right now, trade union officers can be an officer of an affiliated organization out of Hong Kong. So in this case, after this law comes into operation, say after a period of time, an officer needs to report to the registrar, and that would suffice. However, if an officer is an officer of an unaffiliated organization, will have to take into account the nature of the organization. If that organization is a political organization, then that won't be allowed. However, if that organization is an affiliated employment organization or an employee organization, then first of all, the local TU needs to be affiliated with this organization. We want to allow the trade union to be affiliated with that organization. Then the officer can make a report to us saying that he or she has become a committee member or an officer of the affiliated organization out of Hong Kong. These are transitional arrangements. We are still drawing up the transitional arrangements, and we don't have any concrete measures carved in stone yet. Mr. Lai? Thank you, Chairman. First of all, solemnly, I need to say that safeguarding national security is top of mind. We definitely need to plug all loopholes in relation to trade unions ordinance. This time round, the administration is asking to give the registrar more power. I'm all for it. We need to safeguard national security. After the administration publicized the proposed amendments, some international media interviewed wanted persons. They criticized the administration for infringing the freedom of association. Well, I'd like to point out that an element is key. that is legally or lawfully. The freedom of association in accordance with the Article 8 of the International Covenant on Economic, Social and Cultural Rights is clear. Local laws need to be complied with. The right to freedom of association enshrined by Article 27 of the Basic Law is not absolute or unrestricted. The court has already done so. Necessary legal restrictions will have to be put in place in order to protect citizens. I'd like to ask the Secretary some questions. In your papers, you mentioned that allowing the trade unions to consider whether to admit persons who are not ordinarily resident in Hong Kong as their members for talent admission schemes, for instance, say in Zhuhai or other places in mainland China. These persons can live in these areas. And it seems to me that you have the mindset that these workers might not be ordinarily resident in Hong Kong. In accordance with Article 17, you mentioned the phrase ordinarily resident, but there is no specific explanation for this phrase. In other words, we will have to rely on interpretations from the court or common sense. Well, one needs to be really in Hong Kong. Let me give you an example. Many Hong Kong residents go back to mainland China to work. They have an address in Hong Kong. They are electors. They can join elections. But it is not the case that they cannot vote in elections. By contrast, the administration promotes this message that they can vote in local elections. So in the proposed amendments, I hope that you will make it clear, in accordance with the common law, all persons must be an ordinarily resident in one place or more than one. When one is on leave, one would be in Hong Kong as well. They may rest in another place. So the administration needs to take into account this technical issue. Secretary, thank you, Chairman. I thank Mr. Lai for clearly pointing out this point. We talked about the contents about proposed amendments. Some international media outlets sling mud at the proposed amendments this time round. Mr. Lai is very correct. These amendments are in line with the International Covenant's Basic Law, as well as the other legislation. And indeed, we need to abide by the law. The right to freedom of association is not absolute or unrestricted. So, in international labor organization meetings, we emphasize our proposed amendments this time round comply with basic law. That is, the right to freedom of association is not absolute or unrestricted. We have had in-depth discussion with the Department of Justice. For example, in Enhanced Supplementary Labor Scheme, employers do have options. Imported workers don't have to necessarily live in Hong Kong. They can live elsewhere, but they only come to Hong Kong to work. Do we need to make any amendments for these? Our legal advice is that we need to make legislative amendments, and later on we can further discuss it with Mr. Lai Tong Kwok. Next, Ms. LUK Chung-hung. Thank you.
Thank you. I speak in support of the proposed amendments to the trade union regulatory regime, in particular to align it with the national security law in order to uphold national security that would enable the registrar to exercise certain powers over the trade unions according to the national security regime. That's because back in 2019, many trade unions were hijacked by certain elements. They used the name of trade unions to undertake political subversion activities. Well, in the case involving the 35+1 proposal, okay, they say that with 7 people you can set up a trade union, and therefore they call it the 7-up action. So they can repeatedly join different trade unions. So they can join trade union A, B, C, D, E, F, and then another person can join trade union B, C, D, and then they can just set up another trade union using a different name. So in your proposed amendments, have you considered preventing people from doing the same? So for an ordinary or normal person, when a person decides to join a trade union, then they would only be joining 1, 2, or even up to 3 at most. So you would not be registering with different trade unions. So, with the 7 strong council as suggested back then, so why have you not considered that in your proposed amendments? Well, if I can refresh your memory, during the black-clad violence period, there were some inadequacies under the trade union regulatory regime, and some illicit elements might have taken advantage of that loophole, and therefore they might have put in a lot of applications within a very short space of time to set up trade unions, and of course they have ulterior motives behind that move, and therefore this round of amendments is to plug those loopholes. But then the minimum requirement for setting up a trade union would be for 7 persons to apply to get registered. But of course, we have to strike a balance, because upholding national security is our first and foremost priority. But then at the same time, while protecting national security, we would also have to ensure that there would be freedom of association. That is something that we also need to uphold. And therefore, for the 7 person to set up a trade union, we do not intend to change it at all, and we also do not propose to set up a ceiling as to the number of trade unions you can join. So should it be 3 or 5, you will have to justify that. But then if somebody is very strange, because he's joining so many trade unions that you would find it absurd, and therefore you would try to look into that, so that when he tries to set up more trade unions, you can ask him why. But then if you just set a very rigid figure or limit, then it's hard to justify why that is the case, because that would be rather arbitrary. And therefore, when you come up with this round of amendment, other than upholding national security, we would also like to maintain the integrity of the trade union regulatory regime, and therefore we do not believe that there is a need for any rigid requirement as to the maximum number of trade unions that one can join. So it's not that we have ignored that point, it's just that we believe that there is no need to rigidly set a limit. Yes, I believe that many people are watching this, because trade unions can also take part in the Labour Advisory Board, and also the Election Committee, and also the functional constituency elections, and therefore the political involvement in the affairs of Hong Kong would be very high. And therefore, whatever the aspiration of one individual may be, there is always a chance that he might be involved in vote rigging or planting of votes. Yes, the administration might not want to propose any further amendments to the legislation, but then you would also have to pay attention to the fact that there might be people who might want to abuse this loophole that 7% can set up a trade union. Yes, you will have to look at the facts. For promoters trying to set up trade unions, they are very rational. Other than the black-clad violence period, within a very short period of time, we received thousands of applications to set up trade union, and now it's very much back to normal. So for the newly registered trade unions every year, we are talking about a dozen or so, and therefore it's very normal. So just now we also talk about finishing with a new round of registration. Still, we haven't seen a massive number of registration. And also under this regime, and if you set up a trade union with the sole purpose of having one more vote in the Labour Advisory Board election, the cost would also be very high because you have to have all the minutes of meeting and also all the necessary records. Well, in the past, the administrative cost would not be that high, but now it's quite high. But then with your comment, we will take a closer look into that. And if we find out any abnormalities, then we will take a further look to see whether or not appropriate action would be required or warranted under the existing regime. So if there are any abnormalities, we would not permit that to happen. Next, Mr. LUK Chung-hung, protecting national security is, of course, the highest principle that we have to uphold. That has to be very clear, and therefore any registered body or organization in Hong Kong would have the duty and obligation to protect national security. Well, as many colleagues have said, well, during the black-clad violence, well, initially there were only 900 plus trade unions, and yet all of a sudden we have 4,000 more applying to set up trade unions. And of course, we thought that it was something to be welcomed, and yet they have ulterior motives and they are trying to infiltrate our system. And as Mr. Luk just said, well, they try to join the Labour Advisory Board and also the LegCo. So they have ulterior motives. Other than the black-clad violence, which we have to be extremely careful about, well, geopolitics are becoming more tense these days, and therefore people or external forces are trying to use different forms to attack China. So any organizations or bodies who try to help these external forces to impact on our national security should be something that we have to be vigilant about. So for trade unions that are functioning properly with the true intention of protecting members' interests, and if they have no malicious intent of endangering national security, they should not be worried about this amendment. On the contrary, only those with ulterior motives would be raising questions and doubts. And therefore, for individuals raising doubts about the proposed amendments, if it's out of innocence or out of ill-informed, poor information, then we should do more education and publicity so that they can have their fears or concerns allayed. Secretary, yes, thank you, Mr. Kwok, for your support. I noticed that after we have proposed the amendments locally in Hong Kong, whether it's trade unions or other labor groups, as well as the media, well, for those who are fully informed, they would understand that the intention is to protect national security, and therefore, for media agencies that have raised unreasonable attacks or suspicions, many of them are just KOLs not based in Hong Kong, In fact, they are targeting us, and they would use unfounded allegations to attack us anyway. So it's not about our publicity, it's about their intention. But so long as we have the good reasoning, whether it's local or overseas or international queries, is the ILOs and so on. So we can fully prove that all the amendments that we are proposing would be in line with the Basic Law and also the Bill of Rights Ordinance, as well as the International Labour Conventions and so on. We have done nothing less in terms of protecting labor rights. While maintaining international relations would be very important, but then protecting national security would be equally, if not more important, and therefore we will have to plug the loophole in the law to ensure that our trade union regulatory regime would be able to fully discharge its functions and duties, as well as protecting national security. Okay, because this has to do with legislative amendments, I also hope that members can also express their views on this, and therefore I'm prepared to extend the meeting by 15 minutes. So for those who would like to speak, please press the button to request to speak as soon as possible. Next, Mr. Hon LUK Chung-hung. Thank you. Well, I support the proposed amendments. So in 2019 and 2020, we can see that trade unions could be subject to adverse influence by people with ulterior motives, and in fact there are many people who have joined trade unions, and if they are given if they are misinformed, then that would also destabilize Hong Kong. And the nature of Hong Kong is that when we set up trade unions, the purpose is to protect members' interests, and also to ensure that their rights would not be infringed upon. So that's the true nature of trade unions, and that's also the overriding principle for trade unions. And therefore, in this amendment, we try to ensure that national security will be protected, and we would also like to prevent illicit funds would come from external places and so on. And also, we will also have to make sure that funds can also be used in running for local elections and so on. You also talk about overseas workers. Because of the low birth rate in Hong Kong, we might need to have imported workers. In particular, we also need workers from the GBA, and many of them do not have Hong Kong ID cards. And of course, except for very special circumstances, they would not be entitled to applying for Hong Kong ID cards. So under the trade union legislation or ordinance, what kind of protection or safeguards would be afforded to these people who do not have Hong Kong ID cards? Yes, thank you, Mr. Shield, for your support. Well, under the trade union ordinance, in fact, to become a trade union member, you do not have to be a Hong Kong permanent resident. In fact, even for foreign domestic helpers, they have a Hong Kong ID card. They are Hong Kong residents, even though they are not permanent residents of Hong Kong, and therefore, so long as they have Hong Kong ID cards, they can become members of trade unions. So that's the most important part. So they have the freedom to associate. They have the freedom to join any trade unions that they want to join. So under the enhanced labor importation scheme, we have this new accommodation arrangement. In the past, all imported workers will have to stay in Hong Kong, but then now, so long as they have the agreement or consent of their employers, they can also leave Hong Kong to stay across the boundary overnight. So under the trade union ordinance, whether or not they would be defined as being ordinarily resident in Hong Kong, that would depend. Because if the trade union is prepared to accept them as members, and if the registrar also agrees to that, then they can become members of these trade unions. But then we're talking about those who are not ordinarily resident in Hong Kong, who are not staying in Hong Kong overnight. Next is my turn. I support the amendment because, as we can see, Well, during the Black Flag violence, many trade unions were set up, even if they organized strikes that had nothing to do with labor relations. They were politically oriented. They were against the government, and therefore we hope that by this amendment, trade unions would be able to go back to their original intention, so that they would just discharge their duties by serving their members. Because back then, we heard a lot of jokes about trade unions. Sometimes trade unions would, from time to time, receive or have youngsters coming over to say that I'd like to put in my signatures. So why are you signing up? Is it that you'd like to enroll in certain programs or whatever? Well, they said no. But then I'd asked them to show me the message that they have received. Well, in fact, online there have been calls for these people to sign up to become promoters of trade unions, and then I would find out that that's the wrong address. You should actually go next door for that. So you can see that many so-called trade union promoters have no idea as to what kind of trade unions they are setting up, and they have never, ever checked the constitution that they have used to set up such trade unions. And of course, the objective is not to serve the trade union members, and therefore the purpose has been such that they have been manipulated by people with ulterior motives, so that they would be coerced into setting up such trade unions, and therefore the purpose of the amendment is to protect them as well.
係要了解。
So before one joins a trade union, one needs to know the situation clearly. I support the legislative amendment. I have some questions regarding the registrar. She can enter the premises of the TU to inspect the documents and relevant record. As I understand, the police also has the power to investigate the matter as well. Say in a previous case where a speech therapist is concerned, the police also had the power to enter the premises, but then the police has broader powers. The police needs to obtain a warrant from a magistrate before one can enter premises. But when the police has reasonable grounds to believe that on premises some documents are related to national security on premises, the police doesn't need a warrant to enter the premises. Trade unions in Hong Kong may become an international trade union or labor organization. That remains unchanged, but funds received, a disclosure or a declaration needs to be made. Trade unions have the responsibility. They need to know whether the organization undermines national security. For the second level of protection, we need to rely on the LD. So when a trade union receives fund and when one makes a declaration with the registry, can the registry be the gatekeeper? When a fund isn't approved, it probably means that an organization might undermine national security. Thus, local trade unions may have to tread cautiously. As we mentioned, some trade unions are zombie trade unions. We shouldn't think that all zombie trade unions may undermine national security. Some trade unions in Hong Kong are set up in order to resolve labor issues. When the issues are resolved, the zombie trade unions may become inactive. These inactive trade unions may not may not undermine national security. So we may need to strike a balance in this regard. 3 questions. Thank you, Chairman, for your support. I'll give the floor to the Registrar of Trade Unions. After legislative amendment, if the registrar needs to enter the premises to carry out inspections, she'll give you more information. When a trade union becomes an affiliated organization with an organization outside Hong Kong, before approval is obtained from the Registrar of Trade Unions and when the application is rejected, I agree that we need to tread cautiously. There may be an issue with the international organization. Probably the nature of the organization has changed or the source of the income is problematic, is strange. The registrar may not approve the fund if the funding isn't directly related to the trade union. All along, the Registrar of Trade Unions has always tried to strike a balance. On the one hand, we don't want to see zombie trade unions which remain inactive for a long period of time. At the same time, we also understand that for some zombie trade unions that are quite inactive right now, it doesn't mean that they will remain inactive in the future. But after legislative amendments, there will be basic requirements. Say one needs to keep minutes or other records. All these are set out very clearly in the law. However, no matter how inactive the trade union is, it still needs to maintain the relevant record, and the administrative costs will be higher, and that is reasonable. Please remind trade unions they shouldn't stick to what they did in the past. They need to change following legislative amendments. They need to fulfill all the basic requirements. But rest assured, when the registrar handles these inactive trade unions, she'll try to strike the best balance. I'll give the floor to the registrar. Regarding entering the premises of the trade union or a branch of the trade union, the existing requirements is that for Section 37 of the Trade Union Ordinance, well, the registrar or any authorized person can enter the premises. And one can check the account or the member register. We want to make it that non-residential premises registrar or her appointed persons can enter the non-residential premises of trade unions to inspect the account books or the register of the members. The scope is wider, but in general, the premises are non-residential premises. If we find it necessary to enter residential premises of trade unions, there will be requirements. In other words, the registrar needs to obtain a warrant by a magistrate. And the appointed person will have to satisfy the magistrate under oath that the magistrate must grant the power to the registrar or the appointed person to enter the residential premises of the trade union. Thank you. 2 members would like to speak in the second round. If no other members would like to speak, I'll draw a line. Please be succinct. 2 minutes, questions and answers included. Mr. Kingsley Wong. Thank you, Chairman. I'd like to follow up on Mr. Lai's point. I'd like to speak on the requirement in relation to admission of persons who are not ordinarily resident in Hong Kong. Some live in Shenzhen but work in Hong Kong. They may not meet the requirement of being ordinarily resident in Hong Kong. So in this legislative amendment, probably you need to define this phrase in a clearer manner. Some officers don't have Hong Kong ID card, but they are still members of a trade union. The legislative amendments are aimed at preventing interference by organization from a place outside Hong Kong. So all trade union members need to be holders of Hong Kong ID card. The aim is to prevent any external force or external influence from infiltrating into Hong Kong. How can we define this phrase in a clearer manner? We need to ensure beneficial development of a trade union, but at the same time, we also need to prevent any interference by organizations out of Hong Kong. Secretary, well, the prerequisite is that one needs to be a holder of Hong Kong ID card before one can be a member of a trade union. And the registrar needs to give his or her approval. A person who is an ordinarily resident in Hong Kong will have to meet these two levels of requirements before one can be a member of a trade union. Mr. Chao Siu-chung. Yes, I'd like to speak on the definition of ordinarily resident in Hong Kong as well. I'd like to follow up on the Secretary's explanation. For imported workers, can they form a trade union with 7 imported workers in total after they have set up a trade union? All the political rights, say participation in LegCo general election or other local elections, do these trade unions formed by imported workers enjoy the same level of benefits or rights, Well, for the promoter of trade unions, there are certain requirements. I'll ask my colleague to supplement, or I can provide a written response to Mr. Chow after the meeting. This is quite a technical question. Secretary, you can provide a written response. We have trade union registered by foreign domestic helpers. So perhaps you can explain in a written response. Please provide a written response after the meeting. All members have already spoken on this issue. According to the document provided by the administration, they plan to introduce this bill to the Legislative Council in April 2025. I believe members have no objection. As I observe, members representing trade unions or those who do not represent trade unions unanimously support this legislative amendment. Thank you, Secretary. Last agenda item, AOB. There being no any other business, thank you, members. Meeting adjourned.